Hello everyone. Today we have with us Ms. Shruti Gupta. She's a renowned claim consultant and is currently working with Deloitte as a director. Thank you, Shruti, for having us today and taking out time from your busy schedule and discussing on the topic guidelines on mediation and arbitration recently issued by Government of India. Before we divulge into the topic, if you can please briefly describe about yourself and your background as a claim consultant.
Sure. Thanks, Nikhil. Hi, everyone. I am Shruti Gupta, as Nikhil mentioned. I'm a quantum expert with a background in finance and economics. In terms of what I do, I try to simplify complicated situations. I try to put a value numbers to contractual breaches to help our clients, their legal consultants. It's much like fitting together pieces of a puzzle for me. And I'll try to bring that perspective into our conversation today and see if how can the listeners benefit from the experiences that we have had.
Thank you so much. Can you please briefly describe about the work that you provide, the services that you provide when it comes to mediation and arbitration?
Sure. So I am currently a director at Deloitte India, specializing in disputes and litigation advisory services. As part of the practice, we offer expert assistance through our capabilities in expert witness, financial analysis, damages quantification, and evidence gathering through our discovery capabilities. The goal is to equip the clients, their counsels, to help them with analysis, data, information that's needed at each step of the resolution process that they have.
Thank you. So as you are aware, recently Government of India has issued certain guidelines on mediation and arbitration, which recommend use of mediation as a preferred means of ADR than arbitration when it comes to disputes more than 10 CR. So as a claim consultant, how do you see this impacting the way disputes are resolved in India?
I like to answer this question in three parts.
Okay.
So one, does mediation have advantages over arbitration? Are we ready in India for treating mediation as an alternate dispute resolution mechanism? And then turn to the direct question that you have in terms of the impact on the claim.
Sure.
So I don't think we are in denial that mediation has advantages over other forms when it comes to cost, time, flexibility. It's a very customizable process that the parties can opt for. So while, of course, the last decade arbitration has gained prominence, but at the same time, certain issues have come to the fore time and again in terms of long drawn proceedings. It's taking quite a bit of time as what parties thought that arbitration will be an improvement of litigation, while it is, but still it takes quite a bit of time in terms of biases coming in arbitrator selections, and the most important being in enforcement of awards. So while you go through the entire process and then the challenges that parties face when it comes to enforcement. So if we keep that into perspective, I think mediation definitely is a better version for a dispute resolution mechanism. It is very customizable. From the perspective of adopting mediation in the context of India, the Mediation Act 2023 has been a welcome development for institutionalizing mediation. It will definitely sort of facilitate ease of doing business, ease the pressure on judiciary, and of course comes with the advantages it comes with. Having said that, its functioning is also sort of contingent upon the setting up of the Mediation Council of India that was tasked with coming up of rules, regulations, procedures that will make it effective and a real alternate mechanism that's available to parties. Now, turning to the last one in terms of impact on claim resolution. See, we have to appreciate that the guidelines that the government has come up with is motivated by the challenges that the government faces as a litigant and not directly issues that are there with arbitration per se. The guidelines sort of mention about the perception bias that the government entities may have, if they were to go ahead and accept an award without exhausting all possible avenues. Transfer of government officials while they are on the proceedings, the entire team changes and then no one knows what to do. So the solution doesn't lie in sort of picking up another mechanism vis-a-vis overs. I think these challenges are more deep-rooted and therefore clear directions, directives would be needed for government officials to drive it more efficiently, and therefore that's otherwise it will become another prolonged dispute and a forced mediation as an additional step with eventual resorting to arbitration and or litigation. So I think that would be needed. That's a gap that there currently is.
Thank you. So my next question is, as per the recent guidelines, do you think the companies will be willing to opt for mediation than arbitration? If so, what do you think will be the implication on claim consultants?
See, whether companies will go for more or not, mediation as a concept always existed. Companies always had the option to go and mediate and not arbitrate and or litigate. One can argue that yes, the guidelines have come up, more awareness, more advocacy initiatives, and therefore more parties will warm up to trying, mediation, and definitely for the advantages that comes along with mediation. From the perspective of a claim consultant, I think two, three things that I would say will emerge from this shift. Increased demand for mediation experts who sort of focus on collaborative problem solving. So, right, while experts have a tendency to do a very argumentative adversarial analysis to help their clients, the legal counsels to drive that process. So, it's something that will focus on more collaboration. Methodology may change for a consultant. So, of course, not that the facts will change or the assessment will change or the outcome of the analysis will change, but perhaps the way you would present your findings, your recommendations to allow parties to come to a common ground and move forward and try and mediate the matter, try and solve the matter. The third thing that I would say is perhaps room for broader engagement, right? So claim consultant comes in, typically arbitration has started, the statements have been filed by both parties and an expert is needed to quantify. So herein, in the case of a mediation, the engagement perhaps may happen earlier to sort of, test the waters. Where do we stand? What are our weak points? What are our negative points? So which are the points wherein, we would need to sort of bow down a little and accept the situation as it is.
Thank you. So, as a claim consultant, can you please tell us about your experience in mediation matters?
My experience. So I have had the opportunity to be a part of a few mediation matters across sectors in different contexts, shareholders or technology disputes, so on and so forth. The experience has been mixed. I wouldn't say it has always been like, successful and the parties were drawn to an outcome and therefore didn't want to further arbitrate or litigate. So if you were to ask me as to what's the one key ingredient that would make a mediation successful, I will say it's the intent and the willingness of the parties. Because if the flexibility that comes along with mediation is a double-edged sword. If one of them is not into it, has his or her own preconceived notions, ideas, then it's not going to yield any outcome. So until and unless you have that intent, you have that willingness that yes, I am in it to resolve the process, then yes, of course, mediation definitely. There is no denying that it has advantages in terms of, the factors we mentioned earlier, time, cost, efficiency, flexibility. All of that is very real if you are committed to do it.
So my last question, looking ahead, how do you foresee the trends in commercial dispute resolution system in India?
Trends in commercial dispute resolution. See, so of course, evolving legal regime. Every now and then we see up, new rules, regulations, and basis feedback from industry stakeholders and businesses alike. The rules need also to keep pace with that. So as we are actually sort of, making it easy for businesses to do business in India. So that's something, no shying away from. That will be a prominent factor driving the trend. We'll see more technological adoption. So while COVID came and virtual hearings, use of online dispute resolution forums became commonplace, I think that increasingly we'll see use of artificial intelligence, machine learning, considering the kind of data that the businesses today are dealing with. So it's very important that, some of these technological tools are integrated for a better case management perspective. The third and perhaps maybe the last thing that I will say before we part is that more investment in dispute avoidance by businesses, right? So the industry stakeholders are warming up to that idea to proactively take steps and get into a situation which lets them to avoid disputes as opposed to prolonged disputes. And particularly from a construction contracts, we'll see more investment in contract management, risk management, and enhancement of communication protocols, which we realized towards the very end that these are some of the weak links. While you may have a very strong case, but your documentation and all of that is not in order. So that's something we are seeing industry stakeholders warming up to.
Thank you so much, Ms. Gupta, for this enriching session. Looking forward to have you again with us. Thank you so much.